The current Supreme Court term will likely go down as one of the most controversial in history. On Monday, the High Court's 6 conservative justices ruled in favor of some prayer in public schools. And last week, the same justices overturned Roe v. Wade, the 50-year precedent that it guaranteed a constitutional right to abortion. The court also swung the right on guns and another religious freedom case. And several cases still remain on the docket. For more on this, let's bring in CBS News legal contributor Jessica Levinson. Welcome, Jessica.
Thank you.
Let's start first with the rulings on the 2 religious cases. So the prayer case today, and then last week that Maine cannot withhold funds from religious institutions. Do you have a conclusion or a thought about any conclusions that can be drawn about the way this court, the conservative majority, treats religion in American life?
Absolutely. I think we can draw a lot of analogies between those 2 cases and frankly about 3 cases that came before them in the last 5 years. And the bottom line here is that the court's looking at 2 different provisions of the First Amendment that, broadly speaking, protect religious rights or protect us from too much government interference in religion. And what the court's doing is it's looking at this first clause, the free exercise clause, that really protects us as individuals from the government burdening our religious activities. And it's saying that that is the clause that it really cares about. We talked about the Maine case, or you talked about that in the introduction, where Maine created a program where public funds could be used for children to go to private schools. But the program said, but not at religious schools. And the court said that's discriminating against religious schools. We have the decision today, the high school football coach who's saying, I need to be able to show my private belief, my private religious actions of praying at the 50-yard line. The court agrees and says, if we were to do otherwise, we would discriminate against your religious beliefs. In both cases, the court seems not particularly concerned with the other part of the First Amendment, which is the Establishment Clause, the idea that the government shouldn't favor one religion over another, religion over non-religion, or non-religion over religion. We're going to continue to see more of this from this very conservative court.
So, Jessica, there's something I noticed in the dissent written by Justice Sonia Sotomayor, and I want to know if this happens all the time or whether this is a little different. She seemed to take issue with the reading of the facts from the majority. So the majority said that that the coach in this case offered his prayers quietly while his students were otherwise occupied. In the dissent, Justice Sotomayor just put a picture in the dissent. I mean, there was lots of language as well, but the picture is the coach surrounded by football players, essentially saying that the majority's view of the facts was totally wrong. Is that usual, or are we now at the stage where it's not a question of interpreting the Constitution, but a debate over the basic facts of the cases before the court?
I will say that is, for me, a surprising part of the case, that there is still at the Supreme Court level, the ultimate appellate court, that they have so many arguments about the basic facts of the case. Certainly, we have seen that before, but typically speaking, the factual record should be settled below in the trial court. And as the case moves up to the courts of appeals, we should have a kind of basic understanding of what happened. And our question should really be one of interpretation of the law. This one, as you point out, was fascinating because we have the majority here saying these were fairly silent, small displays of private religious belief, private religious activities. And then we have the dissent saying, let's go ahead and look at these pictures. This is not just somebody going to the side, quietly kneeling, nobody really notices. This becomes a group activity. And that matters for the court's analysis, and it matters for the battle between the majority and the dissent here.
So moving on to last week's decision on Roe versus Wade, judges in Louisiana and Utah temporarily blocked the state's trigger laws from taking effect. Is that the normal kind of process the system will go through, or does that suggest that that these trigger laws don't snap into place the way people may have thought?
No, this does not mean that states can't ban abortion or that states can't ban abortion immediately. This is a fairly typical set of circumstances where, in this case, they're basically suing and saying there's this patchwork of trigger laws. We need clarity on exactly what the law is. And so the typical thing to do, which is exactly what happened here, the court issues a temporary restraining order saying, hold on, let's push pause while we sort this out. It doesn't change the impact of the Dobbs decision.
There's been a lot of punditry about Chief Justice John Roberts and whether he has control over the court. Will you put that into context for us? How important is that, and what does it mean for the future?
It's a big deal. He's still the Chief Justice of the court, but I would say this is no longer the Roberts court. And we really saw that with the Dobbs decision, where he just joined in the part of the opinion that would uphold Mississippi's 15-week ban on abortion. He didn't join the part of the opinion where the court overturned Roe v. Wade. The point being that this conservative court no longer needs the Chief Justice. They can afford to lose his vote, which in my mind is a really extraordinary statement, and it shows how conservative this court is. He tried to do this more incrementally. He tried, I think, to have some sort of compromise. My theory that those efforts may have been part of what actually led to the leak, just a theory. But again, I think the punchline here is that the conservative wing of the court no longer needs the Chief Justice.
And finally, as we mentioned, the Supreme Court still has not issued rulings in disputes over Trump-era immigration policy, carbon emissions, Congress's war powers, and Native American lands. Is there one of those that you are looking out for, or how should we kind of think of these last few decisions we've got before us?
So I know it doesn't sound as sexy, but that case dealing with the EPA and the power of the EPA and whether or not the EPA can really regulate greenhouse gases, that's a huge case because it tells us about the power of federal agencies and how much Congress needs to be very explicit about delegating authority to federal agencies. If the court issues a decision that says the EPA went too far under the 1970 Clean Air Act, and that part of the language of the court's decision says federal agencies, you need to pull back, which has been a goal of the conservative movement. Let's pull back on the administrative state. That has implications for every other federal agency. Again, maybe doesn't sound that sexy, but really huge impact for how the federal government runs and regulates and imposes rules.
It's a great point. And it also, next time you hear a presidential candidate saying they're going to do all kinds of things with the administrative state when they get in office, they may not have the powers they think they do. Jessica Levinson, thank you so much for being with us.
Thank you.